Testing, testing. 1, 2, 3. Test. Test 1, 2. Test 3, 4. Test 5, 6. Test 7, 8. Because I hear it perfect on the go back class. Oh yeah. It's lower than that, but.
for being here this evening, everyone. The continuance of Mr. Hanks' meeting dated October 5th at 6:32 p.m. Mr. Hanks, last Wednesday, September 30th, the board requested that we have a continuance for your appeal for the 126606 setback variance request. And again, we have our board less one member because we do not have a replacement for Mr. Owens, who retired. We have Mr. Bob Kelman, our building inspector, here. And do you want us to proceed, since we do have one person that's not here?
Yes.
Thank you. I'd like to ask Mr. Secretary to read the facts from our previous meeting, and then we'll get into the continuance.
The appellant is Dale Hanks, residing at 7455 Walton Road, Walton Hills, Ohio. And this is in reference to Codified Ordinance 126604 F1B. Variance requested, a variance to construct a RV carport. All directives set forth in the COVID-19 stay-at-home order was followed. The entire Zoning Board of Appeals hearing can be seen on the following site: waltonhillsohio.gov. There's a YouTube link which is applicable to this hearing. Chairman Paul Rich called the hearing to order on September 30th, 2020 at 6:04 p.m. Dale Hanks was advised that with the resignation of George Owens, there was not a full ZBA board. However, there was a quorum. Hanks requested the hearing continue without a full board. John J. Montello, Walton Hills legal counsel consultant, was present. Hanks addressed the board, stating the variance would allow the construction of a carport which would be used to protect a camper which he purchased in 2020. The carport would be located in an area which would require a variance to 126604 F1B. Note, the carport would be located on a corner lot which 126604 F1B requires compliance with front setback requirements. Although the referenced codified ordinance was applicable, the ZBA board concluded that codified ordinances 126607 F1 Note 4 as well as 660.17 and 660.18 needs to be considered.
Thank you, Mr. Secretary.
I'm still going.
Oh, I'm sorry.
Okay. Codified Ordinance 126607 F7 reflects that outdoor storage of recreation and commercial vehicles, and I put in quotes, is yard permitted, in quotes again, in the rear. Note 4 states, any storage of recreational or commercial vehicles stored in the country home district must, and that's a key word please, must comply with section 660.17 and 660.18 of the codified ordinances of the Village of Walton Hills, as further regulated by section 1266.10A. 660.17 states, no person shall park a boat, trailer, mobile home, camper, or other recreational vehicle on any residential premise in the Village of Walton Hills closer than 70 feet from a public right-of-way. It further states whoever violates this section is guilty of a minor misdemeanor. After further discussion, Pollock made a motion, which was seconded by Workman and agreed to by Hanks, for a continuance of this hearing in order for Mr. Montello to further research this issue, since it appears that 660.17 is a criminal statute and possibly prevents the ZBA to grant any variance. The motion was approved 4-0. The hearing is scheduled to reconvene at 6 p.m. on October 5th, 2020. There was a motion to adjourn. It was made by Pollock and seconded by Workman. Motion passed. Hearing adjourned at 6:31 p.m.
Thank you, Mr. Secretary. Mr. Hanks, we're back to talking about 126606, which was your original application request. If we were to rule on 660, we can't, because we would be dealing with a criminal offense if we went to 660. So.
But I thought we did away with the zoning part to go to 660. Now we're doing away with 660, going back to the zoning.
Yes, we've been authorized by our attorney, Mr. Montello, that we must stick with the 1266, which was the original appeal for the setback. And 660 is a criminal offense ordinance, and as a board, we don't have the right to vote on a criminal offense. We cannot. We took an oath, and we do not have the authority in this stature to vote on a criminal offense ordinance.
At the last meeting, you said you wanted to move forward with 660 and do away with the variance.
I did, and I did receive some research from Mr. Montello over the weekend, which we needed to get to have this continuance meeting, and that's what I got back from Mr. Montello. Unfortunately, he couldn't be here this evening because he had a prior commitment with the city of Bedford. So I wanted to make sure that we clarify this. Your original application was called out as a variance for 1266, which relates to setbacks, not accessory building, but setbacks on a corner lot. So we're going to continue. Can we continue on 1266? So we did. Do you have any other testimony that you would like before we ask a few more questions or give you some findings?
You know either way what you're going to vote for. It's either a yes or a no. I mean, we're wasting all our time, my time, your time.
Mm-hmm.
So let's have it.
I agree with the procedure.
Yeah, we definitely wanted to ask you if you had any questions before we did vote, and
I mean, we're bouncing back between different stuff, and now we're going back to the original. I don't know.
Well, I just wanted to make it clear that we cannot vote on 660, and our lawyer told us, confirmed that over the weekend.
Well, I'm no longer if I need representation now, because we kind of moved forward with that, but now we're on back. I don't know.
That was one of the things that we wanted to look at.
Right.
It's just something that I discovered in looking at our codified ordinance, and I says, wait a minute, where can these things be parked? And it says you could be parked in the rear, period. Okay? And then it went down to this note 4 with the criminal offense, that if it's parked within the right-of-way, okay, there's a criminal offense. It doesn't say should, it says must. So that's pretty specific.
Well, my address is 7455.
Absolutely.
That is my front.
Right.
Well,
But you have a corner lot, and your corner
that's
lot,
discrimination.
that's something you could bring up with the council. It's just the way it is.
Well, what about, I've been parking there before the ordinance was even written.
Well, we're not.
But not that particular camper, though, right?
Well,
Were you parking a camper there before it was written?
Campers, trailers.
Yeah. You've always seemed to have use of that pad for whatever reason, and we're not discriminating against the pad.
Okay.
Not
Yeah,
at all.
no.
It's perfectly legal. We're not discriminating against
Nobody
it.
ever complained all these years.
Nobody ever complained.
Right.
Right.
And did anybody complain at the last meeting? Did you have any?
I haven't received any complaints or pros or cons for the variance or against the variance.
Okay.
But 1266 is on the table. That's what we're going with right now. I don't. Do we have any comments from the board at this time?
We need to go through those things.
Mr. Rich, I would like you to know that I did go back to the site the Homer site and did make another visit on Saturday, October 3rd, just to refresh my recollection about the issues that were raised at the last hearing.
Okay. Thank you, Ms. Workman. Before we get into vote, you do have a very substantial amount of land to do this in other parts of your property. These are discussion points that we've been communicating on.
I asked you to come out and we would walk
Mhm.
down the sidewalk and show you the elevation of Walton Road compared to the sidewalk, compared to the property, and how you would put an apron in there, and then come under those large AT&T lines is not a height accessible.
I understand that. I understand
And
that.
who's going to pay to lift the lines? And you're going to have to elevate the sidewalk to match the grade for the road, so when you come in off Walton Road, you're not bottoming out.
Mhm.
I mean, if this isn't a hardship case, I don't know what it is, other than the wetland.
Well, I'm not going to get into
Because I
that
can't
yet.
get rid of CEI easement,
Yes.
so that shortens my property up.
Mhm.
If you want that thing sitting out there like a sore thumb, I'm more than willing to do it.
Well, for the sake of conversation, Mr. Hanks, the storage of vehicles should be to the rear of the property, okay? And in this particular case, it's on the front of the property because of the side lot. If you were to park the vehicle parallel to your garage, you would have a slight variance if you were to look at your topographical view here of your property. One of the discussion points we had was if this were to park here parallel, you would
These
have,
are where my garage doors are, when I back out.
you see your garage doors. What is this?
That is an accessory door.
It's an accessory building. So, I mean, this would be considered, but you can't consider doing that because it's too close to your garage, is what you're saying.
Yeah, you got a back. I parked 2 cars.
And additionally, if you were to remove this, you couldn't park it back here. If you were to remove the roof line of one of these breezeway areas, could that?
No, that's ridiculous, I'm sorry.
Okay. All right. These are a couple of the options and discussion points that we've been having as a
Well,
group.
if my car doesn't fit in the garage, I don't cut the front of the garage out to make it fit. You know, I'm sorry, it's just, it's a hardship case, I'm here, trying to do it right. I tried to present everything. I asked you to walk the property with me so I can show you the other property. My hands are tied, I'm sorry.
Okay. Well, before we vote, we generally go through some exceptions or ordinary circumstances or conditions applying to the property for the intended use of the property, and we comment on hardship, we comment on special conditions, we comment on appellate's rights, and we comment on practical difficulties. So as far as hardship is concerned,
Mr. Chairperson, as far as the hardship is concerned, if you look at the applicant's property, it doesn't appear that there's any hardship. In fact, the property, and I did walk the property on October 3rd. I did walk it. I walked it along Walton Road, and then I walked it toward the east, and then back up toward the north, toward the injured workers' home. The property is 339 feet along Walton Road. It is 183 feet in depth. It's pretty much a rectangle. the injured workers, the applicant's house and the accessory building that he has, there's a covered patio, are pretty much along Jefferson Drive, closely to that street. However, to the north side of the home, there is a fenced-in area, and then there's probably at least 40 to 60 feet before you get to the high-tension wires. That area is pretty flat. In fact, I wouldn't think that there's much of an elevation change at all. There is a sidewalk that runs along Walton Road. So I think if you wanted to, next to the sidewalk, there is a mild drainage swale. It was dry at the time I walked it, the complete length of it. There is some areas, 2 areas along the drainage swale where there's some pipe in the drainage swale that's covered already. But it would not be, it did not look like it would be a very difficult proposition to put a pipe in and put a driveway in or access to that other quite a bit of flat land that would be north of the applicant's home. So it doesn't appear, based upon the property alone, that there is any hardship. It doesn't appear that there was any significant wetlands or drainage issues. I had tennis shoes on that day. My tennis shoes, because it was earlier in the day, did have some dew, but there was no standing water that I noticed along the property when I walked it. So I do not see any, the applicant has any hardship as far as the size and the shape and location of the property.
So the high tension wires and the wires along the sidewalk, you felt the wires along the sidewalk were adequate enough for the RV to go through?
Oh, absolutely. Yeah. And the high tension wires run, it looks like east-west.
East-west, right?
Yes, they don't run.
The high tension wires have nothing to do.
No, I'm talking about the electric wires, like the cable wires that run north and south on Walton Road.
I did not notice that it would cause any significant impairment. Okay. Or limit access to that area.
Okay. Thank you. We also cover special conditions. Anyone want to handle that one? I will, I guess. I mean, under special conditions, I mean, is there anything peculiar to the land? And that there really isn't anything peculiar to the land. The land is flat. Ms. Workman indicated that it was dry at the time she was there in early morning, and there is considerable amount of land northwest.
Oh, Mr. Rich, in fact, just refreshing my recollection, I did walk along Walton Road, and as you get to the north of Walton Road, there is a residence that has a driveway access along Walton Road that runs under the power lines. So that residence has a driveway that does run through that area, those wires.
Okay.
Excuse me.
Thank you. Yes, sir.
That driveway is north of the wires? Because that property is mine all the way up to that edge of her driveway. That driveway is not under the high tension wires.
No, not under the high tension wires, under the regular
Under
wires.
the regular wires?
I think Billy's saying the phone lines.
On the
They
same.
had to change the grade so it matched Walton Road. They had to lift that property up. When they put that driveway in, they built that house.
The next part is appellant's rights. Wants to head that?
Would you like me to read that, Mr. Chairman?
Pardon
Would you like
me?
me to read this section of adults' rights?
Yes, sir.
Okay. Applicant's right. If particular and peculiar circumstances arise for the appellant a right possessed by other properties in the same zoning district, each action must be considered determining a variance.
Thank you, Mr. Johansson.
I think in this particular case, that we're dealing with a setback versus your right to build a carport, okay? You have the right to build a carport, but maybe not in the location where you desire to have it built. That's the issue. So your rights to build a carport would not be denied if that's how we go. You understand what we're saying? That you have a right to build a carport. Period. You get the permits, you submit the documentation and everything else, but it's the location of where you want to build it is in question right now.
So, do I have a motion
Mr. Chairman,
regarding this matter? Yes, Mr.
I'd like to
Pollard.
make a motion to approve a variance to 126604 F1B, permitting a setback to erect an RV carport within the 70-foot required setback.
Well, a motion has been made to approve variance 126604 F1B, permitting a setback to erect the RV carport within 70-foot setback.
Correct.
Is there a second?
I second the motion.
Seconded by Ms. Workman. A motion to approve by Ms. Workman. The vote on the motion, Mr. Johansson,
No.
Ms. Workman,
The variance is substantial. It's completely within the setback of the public right-of-way. My vote is no.
Mr. Pollack,
No.
and I vote no. The variance is not passed. Its decisions of the board are final, and further action by Mr. Hanks regarding the board decision may be appealed to the Court of Common Pleas. Court action must be instituted within 30 calendar days of the date of the decision, which shall be filed with the building department and will be mailed to the appellant. Once the board has decided on the issue, the same issue will not be permitted to come before it again within a period of 1 year of the date of the decision. You understand what your rights are on appealing?
Unfortunately, yes. Thanks for your time.
Thank you. Do I have a motion to adjourn this hearing?
Make a motion to adjourn.
I second.
The motion, thank you. Vote on the motion, Mr. Johansson,
Yes.
Ms. Workman,
Yes.
Mr. Pollack?
Yes.
And Mr. Rich votes yes. This hearing is concluded at 6:55 p.m. Thank you.